Hello everyone, good morning and welcome to another webinar which FADA has brought to you, this time on the topic Consumer Protection Act. I am Saharsh Damani, CEO FADA, and while we have already done few webinars and write-ups on this topic, there were few questions and queries coming on our WhatsApp group about how to deal with this Consumer Protection Act. So we thought, why not do a refresher program on the same? And therefore, we have Mr. Anand Jha, who is an advocate on record, Supreme Court, and he has been doing the earlier webinars and has done write-ups also on this topic. But before we move ahead, I would also want to introduce our secretary, Mr. Amar Jatin Sheth, who is present on this webinar. I'll request Amar Bhai to share his opening remarks, and then we can move ahead on the topic. So, Amar Bhai, over to you.
Thank you, sir. And welcome everyone on a Saturday morning joining this call. I think these webinars that Sarsh and Anshul keep arranging are extremely important. It shares with all of us a lot of insights, a lot of new developments that are happening in our industry, in the macro space in general, because the laws are very quickly changing. We cannot keep abreast of them every time. So it is these experts who join us on these webinars that give us insights into them. Generally, when there is a problem at that time, we try and find a solution. But I think it's better if we are well prepared in advance and aware of what our rights are, what are correct ways of doing business. That would help us much more. So today this webinar is on the Consumer Protection Act, and we have Mr. Anand Jha, who is the advocate on record at Supreme Court. He has been kind enough to join us earlier also on the webinars and shared his immense knowledge with us. I think it was very well received. People had a lot of questions, and a lot of queries got clarified on the call itself, and those which did not were answered later on. So thank you, Anand, for always being there for FADA and joining us on these webinars and sharing your knowledge. Consumer rights is, I think, a very vast chapter. It is also quickly evolving. We, being a dealer, are in that pivotal position between the manufacturer, which makes the product, and the dealer who gives the service. So a lot of laws are applicable to us, but what is the correct interpretation? What are our rights? What are our liabilities also? Where do we have to protect ourselves? Things like warranty, advertisement claims, what is deficiency of service, what is a product liability. I think all those things are extremely crucial to understand correctly. So today on this webinar, I think we will have a lot of clarity on that, and I'm sure you all will have a great 1 hour today with us. And thank you once again for joining. Thank you, Sarsh and Anshul, for arranging this and taking efforts to enlighten the dealer community. I think Anandji, over to you, and looking for great insights today too.
Thank you, Bhai. Anshul, if you can just pull up the presentation, and while the presentation is coming up on the screen, we have a Q&A box where if any of your doubts, if you have, you can mention it there, and towards the end of the presentation, we'll take all those doubts. Not in the chat box, but in the Q&A box. So Anandji, over to you.
Yes, good morning. Thank you, Saharsh. Thank you, Mr. Sheth. Thank you, Anshul, for helping me run this presentation. And a very warm welcome to all the friends who have taken the effort to join us on this Saturday morning. I really hope, and I sincerely hope, that we'll make some good use of next 60 minutes. And I'll be able to address some questions, and we'll be able to understand some of the concepts which either you are facing in any of the matters which are going on, or you may in near future will come across one of those topics. Before we begin this presentation, I want to spend 2 minutes to explain as to why this topic is of some importance to all of us. Now, as you know, in the present world and age, we are regularly and constantly dealing with commercial transactions. We are selling products, we are buying products, we are in the process of engaging with our customers at various levels. As dealers, you are engaging with them as seller of a particular product, as service providers. So it is this law, which is the Consumer Protection Act, which was earlier of year 1986 and now is of year 2019, which lays down the framework, which lays down basic ground rules for the game. It sets out who is the consumer, who is the service provider, what is the standard of service that is expected of you, what is the standard of service that is expected to ensure that the activities that you undertake do not fall within the purview of what is called an unfair trade practice. It also sets out the boundaries to decide as to what will fall foul of a product liability action, what are the things for which courts are going to hold us as service providers responsible, what is going to be the quantum of compensation they may possibly award, what are our rights and remedies in case we are not satisfied with a judicial outcome. Let's say we are not satisfied with an outcome of a district consumer forum, where do we go? Or we are not satisfied with an order of a state commission, then where do we go? And then this also broadly tells us that what are the ways of risk mitigation. The underlying word throughout this present seminar or discussion session is going to be risk mitigation. How best or what best can we do in order to minimize my risk? The risk is not only financial risk. The risk could be the reputational risk that you may have. The risk may be the risk of being wrongly projected on a social media platform. So these are various kinds of risks. What are my rights as a dealer? What can I do if someone is, let's say, taking an action which is not commensurate to the legal standards? We will discuss all of this, but today's presentation, I want to focus on some of the core concepts of the Consumer Protection Act. What my friend Mrs. Sheth said, that it is a vast subject. It takes practitioners the entire lifetime to understand and grapple through the various issues that come to us. But if we can encapsulate it, if we can put it in a very concise format, that is what I have tried to do. Let us first begin with this presentation, and Anshul, can we go to the first slide, which is the introduction slide?
Yes, sir.
Right. So there's a very brief history to this law. It was first enacted earlier at the very original form. It was under the law called MRTP, Monopolistic and Restrictive Trade Practices Act. But MRTP dealt with something different. It was not directly concerned with the deficiency in service which I as a consumer may face. So in year 1986, there was a very groundbreaking legislation which came by the name of Consumer Protection Act 1986. It of course required a lot of overhaul over a period of time, because you understand how the business was done back 35 years ago is not the same as it is done today. There are various new things which have come into existence. For example, social media, for example, advent of internet, on which most of the transactions now take place. So the law required some amendments over a period of time. There were various concepts which required overhauling. For example, financial thresholds required some overhauling. The monetary limits which were set under the original law in 1986 were no longer considered to be very relevant for the present day and time. So therefore, there was need for an amendment, and the government of India also felt that while there is a adjudicatory body which is in place. When I say adjudicatory body, I mean there was a body where you could go to and lodge a complaint and which will decide your matters. There is no body which will catch them as a regulator. For example, for a insurance, in the domain of insurance, you have Insurance Regulatory Authority. You have Securities Exchange Board of India when it comes to the securities markets in India. So for the consumer protection, it was considered necessary that we should not only have what is called remedial measures, we should also have measures which would preempt a scenario where a customer as a group is going to be impacted. For example, by way of some misleading advertisement, or by way of some promises which were made which were completely impossible. So there should be a body which would look at the consumers as a group and would try to preempt and provide a solution to those issues which may later turn into litigation, and for which a body like Central Consumer Protection Authority was found in the new legislation. So there were various grounds, and we will discuss some more reasons as to why there was a need for change. The objective of this law is just as noble and good as any other legislation would be. So as the slide suggests, the present legislation was aimed at safeguarding the consumer rights and interests. Secondly, it was to ensure the fair trade practices and consumer welfare. The Act provides a mechanism for consumer grievance redressal. The word is redressal. And the next is enacted to promote accountability amongst businesses. Okay. The sum and substance is that this law wanted to provide a mechanism under which, in a timely fashion, if any of the consumer rights have been infringed, they can be redressed. Now, in this, more often than not, we as dealers would find ourselves in the capacity of respondents, because we will face litigations from our consumers who are possibly dissatisfied, maybe with the OEM, or maybe with some of the warranty conditions not being met. So this law is going to be of some importance to us throughout the course of business, whether it is in the areas of the representations that we make to the customer, whether it is in the area of the billings that we carry out, whether it is in the area of how we report to the government agencies, how we deal with them in terms of after sale services. All these areas are going to be governed to a large extent by this law called the Consumer Protection Act. You all, as reasonable businessmen, would have also come across, the government has put in a lot of thrust in sensitizing and educating the customers regarding this legislation, unlike any other legislation. So you would have a lot of advertisements going on in newspapers or electronic media by the name of Jago Grahak Jago, under which the government wants to make it more and more easy, accessible for the consumers to approach the court or to approach the consumer helpline in case they have an issue. It's one of the objectives of the government. And that has again led, we have seen over a period of time, the number of litigations we used to handle, let's say 10 years ago, for an OEM or for a dealer has easily gone at least 3 to 4 times in a span of only 10 years. And in this, I also include the matters which don't land up in court, which come to us, let's say, in form of complaint emails, in form of tweets or social media posts which are put, and most importantly, the legal notices and the cases which come to us. Okay, so in view of the fact that there has been such massive explosion of the number of matters which are reaching before courts, it is equally important for us, and secondly also because the penalties have now become even more burdensome. It is important for us to understand what are our rights and what are our obligations under this law. Okay, so with this, Anshul, can we go to the next slide, which is the slide on the objectives. Now, as I mentioned just a while ago, the objective of this law is protection of consumer rights. Okay, so when you approach this subject as a dealer or as a service provider, you must keep one thing in mind: the law, the scales are slightly tilted in favor of consumer rights. Okay, so don't be surprised tomorrow when you go to a court and you find that the court is more, shall we use the word, predisposed towards the interest of the consumers. Okay, the word of a consumer is rather taken sometimes on the face value. If a consumer says that I am facing a particular problem on a recurrent basis, although as per the regular standard of a litigation, that consumer might be asked to prove it to the last word. Under the Consumer Protection Act, or the bodies which administer this law, they are more predisposed towards the interest of consumers. So that is the first objective, which is right to safety, information, choice, representation, redressal, and now what has been added, the education of customers. Okay. The second is the mechanism has been provided. You see, the mechanism was there under the old law as well. There was a three-tier mechanism which existed under the 1986 Act. The mechanism was District Forum, State Commission, and the National Commission. Okay, and the appeals would go from District Forum to the State Commission, from State Commission to the National Commission. And now there is a new judgment which has come in this very year 2024, under which in some of the scenarios, the judgments of National Commission, instead of directly going to Supreme Court, will go before the concerned high courts, and then from there it will go to the Supreme Court. So it's a long chain which is there. At various financial threshold levels, the customer, depending on his grievance, can approach these courts. We'll discuss these thresholds in the coming few slides. All right, so the next one is fair trade practices. In the present law, while it is not only important that you meet what you have promised as an OEM or as a service provider, it is also important that you do not engage in anything which either comes under the head of misleading, exploitative, or which goes on to represent to the customer and may be called as an unfair trade practice. Okay, so that is one area on which there's a lot of focus now, because the authority which has been set in place can pass sweeping directions of not only imposing penalty but also directing you or a manufacturer or a service provider to stop doing a particular practice which he or she has been doing over a period of time. The other objectives are consumer empowerment, which is, of course, educating the consumers, the media campaign which you see is running, or the social media portal which has, the online portal which has come. So earlier in the day, you had to go to a particular court, lodge your complaint, the matter would go on. Nowadays, at the click of a button, you can lodge a complaint, and the process under the aegis of consumer helpline starts. And therefore, it's become more and more accessible for consumers to seek redressal. There is possible enhancement of accountability. Okay, so as you are aware, the penalties are also increasing with the increasing number of judgments or increasing number of cases which we are seeing, and timelines are becoming stricter. The deposits are becoming more and more onerous, and therefore it is very important that we as the service providers keep ourselves updated and are pursuing the litigation in full earnest. Okay, and because back in the day, if I had to file an appeal against a judgment, let's say a district forum passes a judgment directing me as a dealer to pay an amount of 10 lakh rupees, I could have challenged that judgment before the State Commission, or I could have challenged that judgment of State Commission before the National Commission by making a smaller deposit of 25,000 or 35,000 rupees. The thresholds have now changed, as I said. Now, earlier, while before 2019, you would have filed an appeal by making a simple deposit of 25,000 rupees. Now you will have to deposit a 50% of the total amount, which will remain before the court till the time the matter is decided. And therefore it is very important because it has direct financial consequences for somebody who's contesting the litigation. Secondly, many a times the delays which are caused in the process of your persons coordinating with lawyers or law firms who are handling the matter, that is also coming at a very serious cost to the dealerships. Okay, so with this, let's go to the next slide, which is the slide about broad concepts around which this entire law revolves around. The first is, what is the definition of a consumer? So consumer, as you understand from the very word, someone who consumes, but it is defined legally under the Act to say a person who buys any goods or avails any services for a consideration. Okay, so consideration means there has to be something paid in return of that service, excluding resale or commercial purposes. Okay, So a resale activity or something which is done purely for a commercial purpose is excluded from the purview of this act, and a number of matters that we contest are under the definition of what amounts to a commercial purpose. Okay. In the present law, a transaction made by either online or offline method, they are both kept under the definition of consumer. So a person who's buying any good or availing any service from you for a consideration, so far as it is happening for a consideration, and so far as it is not for the purpose of commercial usage, okay, till that extent he is under the definition of a consumer. However, if somebody has bought a particular vehicle from you for commercial purpose, okay, now commercial purpose has a definition which broadly means that it is not for personal consumption. I have bought a fleet of 10 cars on which I will put drivers and they will run and the company will earn profits out of that. Then that company which has bought those fleet of 10 cars is not a consumer. But if I, as a sole driver, have purchased a car from you, it may be a commercial car, but if it is for my personal employment, for my own usage, I'm driving it myself under the aegis of an aggregator called an Ola or an Uber or any other aggregator, and I am earning livelihood out of that, then I'm a consumer. Okay. Secondly, what is deficiency? So we don't want to take you through the complexities of it. But broadly, I mean, if somebody has to, as a layman, understand that whether I will fall within the definition of a deficiency in service or not, keep in mind these words: shortcoming or inadequacy in quality. Okay. Secondly, the nature, manner, and the performance under the contract is not satisfied. If any of these two broad heads are met, it falls under the definition of what is called deficiency in service, okay, or deficiency in the product. Next is injury. You see, it is very important in any legal action for a person who claims himself to be a consumer to be able to demonstrate that I have received, or I have, as a process of having availed your services or consumed your goods, I have been injured in the process, I have been harmed in the process. Okay. And unless a person can show that, there is no cause of action for him to really go before a court. Okay. So therefore, in every legal action, the very first test which you should do as a service provider or as an agency which has sold a particular vehicle is to first test that whether the person who has now raised a complaint against you, is he a consumer or is he somebody who is using it for a commercial purpose? Secondly, whether you have committed advertently or inadvertently deficiency in service or unfair trade practice, and as a result of these activities, has the person suffered any injury? Okay. So if the answer to all these three questions is in affirmative or is yes, then we move on with what is further important. That is the definition of what is a product, what is a product liability, and what is a product liability action. Okay. See, product is something which is fairly straight cut. It is any article or goods manufactured, distributed, or sold. Okay. So there is no question that whether what you are dealing with or what you are selling is a product or not. It certainly is. But under what heads there can be a product liability action is something which is important to be seen. Okay. So product liability action is something which is product liability is something which is defined in very simple terms under section 2, subsection 34 of the Act. And I want to take 1 second to read both the product liability and the product liability action. Product liability means responsibility of a product manufacturer. You are not a manufacturer, or a product seller of any product or service. So you fall within the definition of what is called a product seller. So therefore, there can be a product liability action against us as members of FADA. And to compensate for any harm caused to a consumer by such defective product manufactured or sold, or by deficiency in service relating thereto. So this is the definition of product liability. Next is the product liability action is defined as an action which is taken by a person before a district forum, state commission, or a national commission in relation to for claiming compensation for the harm caused to it. Okay? So if any person has suffered what is called a deficiency in a product liability or has a complaint in relation to a product liability, he will institute what is called a product liability action. Product liability action, as I mentioned, can be against the manufacturer, but at the same time, it can also be against the product seller. And therefore, under the head of product seller, what are our obligations? We will discuss in the chapter of product liability actions. But you will understand and you will hear this word product liability more and more. This is a relatively new concept in India, which has really found a shape under the 2019 Act. You would have heard various instances of a particular model has been recalled, a particular batch of vehicles have been recalled. Okay, now that all can possibly face a product liability action from the consumers, or a group of consumers can come together and raise a product liability action. And this is one area for which most of the international car manufacturers or OEMs are wary of when they face product liability actions. So any notice, my request would be that if any of you receive any notice which specifically uses terms like product liability or product liability action, in which a possible threat or a warning is given that we are going to take a product liability action, it is all the more reason for you to consult and give a very considered response to such a notice or to such a complaint, because that has a possibility of snowballing into something much bigger, not just for you as a dealer, but also for the OEMs, because you are although we function on a principal to principal basis in most of the cases, you are considered the rightful representative of an OEM. For a common man, in fact, for many of the legal minds also, you are the first touch point for any person who has a grievance against you or against the manufacturer. Okay, so this requires a greater level of diligence. With this, Anshul will take us to the next page of the slide, which is unfair trade practice, restrictive trade practice, and misleading advertisement. Okay. See, under the new law, as I mentioned, there is a lot of focus also on the area of what is considered unfair, restrictive, or misleading. The terms are simple English terms, but it is very expansive in nature. It can bring within its fold a lot of things. So what is an unfair trade practice? Any deceptive practice, including a false representation, misleading advertisement, or selling of goods not meeting the standards, is unfair trade practice. And to all my friends who are listening to this, you will find some overlap between these definitions of unfair trade practice, misleading advertisement, and to some extent restrictive practices also. While it is for the practitioners to focus as to under which exact bucket the matter is going to fall under, there are different thresholds and there are different defenses which are available for all these violations. What is important is to see that an unfair trade practice deals with a scenario of a deceptive practice of false representation, a misleading advertisement, or selling goods which do not meet a particular standard. Okay, you would have had maybe some complaints with respect to let's say fuel efficiency. There is a group of industry consumer agents bodies which took an action under which they complained that the OEMs are representing their vehicles to have a fuel efficiency of, let's say, an 18 kilometer per liter or a 24 kilometer per liter. And of course, they write with asterisks that it is under which conditions and ideal conditions and various other caveats are given. But they are deceptive practices. Okay, we have had matters which have gone right up till the National Commission, where the courts have held that all the pomp and show which was done at the time of a launch of a vehicle or at the time of a delivery of a vehicle or an advertisement that you ran gave the consumer an impression that the vehicle is so sturdy that it will possibly ride a mountain or it will go through the water bodies and without being impacted in any manner. these advertisements do leave a scope where a person can possibly institute an action in relation to misleading or an unfair trade practice. Okay, because you see, an unscrupulous customer or a customer who has, and in most of the cases we don't come across people who are genuinely aggrieved. See, those who are genuinely aggrieved will genuinely approach you and will have reasonable expectations out of you. But in a country like us, which is quite litigious, as I may say, and where people are quite aware of their rights, not as much of their responsibilities, but certainly of their rights, that you will find actions in which unfair trade practice or misleading advertisement, or for that reason restrictive trade practices, are alleged. And we have seen that many a times a simple pamphlet issued by a dealer has also held an OEM responsible, and many a times the dealers are made to answer questions with respect to some of the promises or some of the things which are put up by the OEMs. So let's with this look at the definition of what is restrictive trade practice. Section 2, subsection 41 defines a practice that manipulates the price or conditions of delivery to hinder competition. Okay. Now, this definition is partly in the realm of consumer laws and partly in the realm of what is called in the realm of Competition Act. Okay. Because here somebody is manipulating the prices or conditions of delivery to hinder what is called the competition in the market. Okay, to gain a greater market share, or to oust a competition in the market, or to compel a particular set of dealers in the market. If a particular condition is imposed by the OEM, it may come within the definition of a restrictive trade practice. Okay, so restrictive trade practice is something which is basically which disturbs the equilibrium of the market in terms of price manipulation, delivery manipulation, or imposition of a term which may lead to disturbing the equilibrium of the market. Okay. Now, one second. Next is misleading advertisements. An advertisement that falsely describes a product, service, or misleads about its nature, quality, and substance falls within the definition of misleading advertisement. Can we now go ahead with the next slide, please? Now, key changes. I mentioned that under the new law, the responsibility of us as dealers has really has undergone some change. It has become more and more onerous, if I may use the word. It has become financially more painful for us because, as I said earlier, I could have filed an appeal with a 25,000 deposit or a 35,000 deposit. Now I need to deposit 50% of the amount. Mostly the courts are not granting any stay without a requirement of having deposited 100% of the amount. Okay, so we have had cases where it is absolutely impossible for the consumer to justify that how he has a valid claim against us. Cases where he has sold the vehicle, cases where he has received the benefit of total loss in case of an accident. But still, when we as dealers or a manufacturer files an appeal in the matter, the courts direct us to make the deposit of the full amount of money. Now, while one may have to deposit the money so that you ensure or you give the comfort to the litigant that the money is in the system, it sometimes also causes a problem of lot of good funds being blocked in the court process. Okay, so maybe let's say you have 10 cases where 25 lakh rupees is in deposit. The overall sum which is lying in deposit before a court of law is a very substantial sum just with 10 cases. So imagine that these deposits can go on to really trouble us in the longer run, the more matters that we fight. Then the new law also provides for something which is new and different. I don't know how many of you have really taken advantage of this or have done this. The new law has a compulsory mechanism of mediation. Okay, so every matter that comes to you, at the initial instance, before the matter goes forward, if both the parties are amenable to reason and they are open to dialogue and discussion, It provides a forum where under the aegis of the court, you both can sit together and you both can arrive at a settlement. That settlement will be done by the respective district commission or a state commission or a national commission. And that is an order of the court. That is just as good as an order of a court. It is binding on both the parties. It is something with which both the parties are going to put an end or a quietus to the litigation. And therefore, if you have a matter where you are able to sit for a mediation with the other side, you must give it a shot at the beginning of any litigation. Because as I said, the court process is a long drawn process. There's a 3-tier mechanism which is there, and then some matters land up in the High Court and some matters land up in the Supreme Court. It is better if these matters are finished at the very beginning, and you, without having to spend any money, can avail the benefit of this mediation mechanism. And we have, for a number of our clients, mediated matters as serious as airbag issues or engine related issues, where we can say that, in fighting the matter for 7 years, the person will end up spending more money than the cost of the vehicle. So it's better that you both close it within a span of 2 weeks or 4 weeks, and then finally arrive at a settlement. You provide some benefits or he gives up some of his claims, and you make a binding court order by way of a mediation process. Okay. The present law also has expanded the rights and has granted greater protection on the issue of misleading advertisement. Mind you, under the present law, there is also an introduction of liability of what is called endorsers. Okay, so people who, let's say, celebrities who are endorsing a particular product, or some celebrity is having a cup of tea and saying that it has health benefits, or somebody is using a particular vehicle and says it is the safest vehicle under the sun. So these kind of promises, when they are made by celebrities, earlier they could have said anything and everything and they could have walked away from there. But now no more. Under the new law, even the endorsers have a responsibility, and they cannot get rid of the responsibility simply by saying that I really believe that this Chavanprash will make me feel healthier and I will never catch flu or cold throughout the season. So the endorser now has a responsibility of not just doing the advertisement or accepting the money. He also, or she also, has a responsibility of seeing that the promises that he or she is making is reasonable and believable. It is not something which is, one cannot claim that I am having gutka and that will give me energy. So you cannot make absolutely bald and baseless claims. You should have done a prudent test or prudently tried to find out that, whether the claims that you are making are genuine, honest, and has some backing in facts or not. It may not be technically like an expert, but you must have done some effort to find out that the claims are genuine. Okay. So the responsibility which this new law puts at every possible level has increased. It has brought within its fold the e-commerce transaction, the online transaction, and the digital platforms. Okay. So a lot of our services are now going to be affected on the online platform. Your responsibility is as crucial or as important on an online platform, and in fact there the things are even more documented. So therefore it's very important that you be very careful under the new law, because a wrong representation can expose you to a serious risk of misleading advertisement or an unfair practice. Okay. Now, under the new law, there's a provision for e-filing of complaints. Earlier, you had to go with a paper complaint to be filed, and now the complaints can be e-filed. Let me tell you, there's something very new, important, and to some extent disturbing development which has happened under the new law. For example, I am somebody who's based in, let's say, Jamshedpur. I go and purchase a vehicle from your showroom, and the vehicle is of a manufacturer, let's say Hyundai. The person gets transferred from Jamshedpur to a place in Madhya Pradesh called Bhopal. Earlier, under the earlier law, the complaint had to be filed at a place where the defendant is situated. When I say defendant, I mean where either the manufacturer is there or the dealer is there, or where the service has been availed, or where the cause of action has arisen. But under the new legislation, the complainant can file a complaint anywhere where he is there. So in order to make things more and more convenient for the complainant, this person who had purchased the vehicle at Jamshedpur can go and file a consumer action against a dealer based in Jamshedpur, and that case will be accepted in Bhopal, it will be accepted in Trivandrum, it will be accepted in Kohima. Meaning thereby, and that has its own flip side and implications on us. Let's say I'm a dealer based in Delhi and I have to defend a matter at Trivandrum. I will find it very difficult to find a reliable lawyer there. I'll find it very difficult to find a reliable support system there. However, to make the law more and more beneficial or more and more helpful to a consumer, this benefit has been granted that wherever the consumer is, he can go on to file an action. And this is now leading to a situation where in a lot of matters we are seeing that either the respondents or dealers are not able to file their replies on time, are not able to effectively represent themselves in those matters. And in many cases, not only that, let's say if I'm based in Bhopal, I have my support staff in Bhopal, I have my legal team, I have my people in Bhopal. I can always go to a nearby court and find out if there's an order which has been passed. We are increasingly seeing where orders have been passed, months have gone by, and the agencies or dealerships are not even aware about the orders which have happened against them. And that has a snowball impact in future. So tomorrow when you go in appeal, instead of talking about the merits of the dispute, the facts of the matter, the court talks about what you were doing for last 6 months, why did you challenge the matter so late, and therefore we will not entertain you. So therefore, as I said at the beginning of this presentation, the scales are slightly tilted in favor of the consumer. It is more and more important for entities like us to show greater alacrity, to be more alert and aware insofar as defending litigations are concerned. With this, let's move to another key change, which is product liability, wherein under the old law there was no specific provision, but under the new law there's a specific liability which is casted on not just the sellers but also on the service providers and the product sellers. The unfair contracts, there was no provision under the earlier law for unfair contracts. Now the contracts which are by their very nature exploitative. So you would ideally not get into contracts which are exploitative in nature. There was a judgment of National Commission on the issue of credit cards, which said the credit card companies cannot take interest beyond a particular point, beyond say a 30% or a 40%. Now even Supreme Court has upset that judgment, but the point was you cannot make a contract just because you have a greater bargaining power and make the entire arrangement exploitative. For example, a builder cannot say that before even I do the groundbreaking, I will take 100% of the money, and if you don't pay that, I will charge you a 40% interest on that, okay, or a 30% interest on that, despite having no liability of having started the construction or having gone as per the various milestones that he's supposed to meet in the process of construction. Okay, so even the unfair contracts are now being looked into. Mind you, all my friends, there are an increasing number of litigations which are coming on this heading of unfair contracts or unfair trade practices, which relates to the issue of the warranty manuals of our OEMs. A number of warranty conditions are now being challenged. While it is important for us to know that this is there, we as dealers have no responsibility of what are the warranty conditions. We are nothing but passing on those warranty benefits as per the terms and conditions of warranty, subject to the instructions of the OEMs. But you will see more often than not, you get embroiled in a dispute between a OEM and a consumer, and because you are the first point of contact, you also get pulled into the litigation. So it's very important that if in a matter a particular term of a contract or a particular warranty condition or a condition which is given in the manual is questioned, it is very important that that matter deserves a greater level of diligence or has to be contested with greater seriousness, because it has impact for not just one manufacturer but for several manufacturers. And secondly, of course, your long-standing relationship with a particular manufacturer also comes in question. Okay, so such matters have to be will have to be contested with greater level of diligence. Let's come to the next important change, which is with respect to an agency that has been brought in by the name of Central Consumer Protection Agency. Now, while you all know that there was no agency of this nature earlier, we have a consumer regulator. So if I put it in very simple terms, like you have, let's say if there is a fraud that happens to you in the stock market, you will write to the Securities Exchange Commission of Securities Exchange Board of India. If you have a complaint with an insurer, you will write to IRDA. Similarly, if there is an issue with respect to the consumer rights, you have a regulator of sorts by the name of the CCPA, which is the Central Consumer Protection Authority. Okay. Somebody has raised hand. I would just request that we'll park all these questions and discussions for the end of this presentation, and kindly let us just finish all the bullet points which are there. Okay. So then there is under the new law, what is also important for you to briefly know, because by virtue of the fact that you are attending this presentation, I also assume that you must be the point of contact, or you must be the concerned person who would be dealing, or on whose table these complaints or cases would land up as the first point of contact. So under the old law, the jurisdiction, the pecuniary jurisdiction or the monetary jurisdiction of district forum was till 20 lakh rupees under the old law. The state commission was from 20 lakh to 1 crore, and from 1 crore and above was before the national commission. These thresholds have undergone a change. While under this act, you would find that the thresholds were changed almost 10 times. The thresholds were then tweaked in year 2021, and the presently existing thresholds are that for a matter where the sum in dispute or the amount in dispute is less than 50 lakh rupees, the matter will go to the district forum. If the sum in dispute is from 50 lakhs to 2 crore rupees, the matter will go to state commission. And if the sum in dispute or the total consideration which has been paid by a party is more than 2 crore rupees, the matter will straight away go before the National Commission, which is based at Delhi. You also must be aware that there is an appeal provision. So if you are dissatisfied with, let's say, a judgment of a state commission, you have a right to file an appeal. Similarly, you can file an appeal from a district to a state commission. And there are various other provisions also which your lawyers will advise you about: revision, review. What is basically important for you to understand is that all the defense that is developed, and I want to lay some emphasis on this, because we see a number of cases, all the defenses which are developed are best developed at the court of first instance. Okay, like when you build a house, you always give the maximum emphasis to the process of laying down the foundation, because that is one thing which can never be changed, right? Similarly, in a litigation or a consumer litigation also, if your drafting and pleading at the district forum level is bad, you can't imagine that you will hire a very expensive lawyer in National Commission or Supreme Court who will make the entire case undergo a change. No. We ultimately deal with the same set of pleadings and facts which you present before the court of the first instance. Okay. So it is very important that you handle the matter at the first instance with the greatest amount of seriousness, because 5 out of 10 matters are lost not because a dealer is responsible or not because a dealer has not provided service of a particular standard, but 5 out of 10 matters are lost because the replies were not filed in time, because all the documents which were to be introduced at the very beginning were not introduced by our friends or our lawyers who are there at the district level or at the state level. And we have many a times, we know that we have a very compelling case, very good case, but for the want of the fact that they were not introduced at the very first level, at the very first instance, we are hand-tied in our appeal proceedings, and a consumer who steals a march over us in this process I'm not saying that they should not win. If they have a valid grievance, then obviously the entire legal system must help them. But many a times, even unscrupulous consumers, those who have used a vehicle for a 2 lakh kilometers or a 1 lakh kilometer, will still come after 1 lakh kilometer and say that, no, the clutch is giving me a problem. So after having driven 1 lakh kilometer, I want a new vehicle. Sometimes even such litigants are helped by courts. And the problem which arises is that we see that our pleadings or our papers at the lower level are lesser than what we would have expected. And that is a lot of problem for us at the appellate level. Okay? With this, I want to leave you with the broad headings of what is called deficiency in service, which I'm sure will take us to the next slide. Basically, keep these broad heads. Definitions are not for anyone to remember. Whether there is a failure to perform, whether there's an inadequate quality, whether there is misrepresentation or deception, non-compliance of standard, or harm or loss caused to the consumer. These are the broad things which are seen by the courts or the bodies which decide your disputes while arriving at a conclusion that whether there is a deficiency in service. Okay. And with this, let us also, we will discuss a lot of examples also. Let us go to the slide with respect to unfair trade practice, which is 2 slides from this one. Unfair trade practice is defined under the Act to mean any false representation or misleading advertisement made by a seller to promote goods and services, and practices intended to deceive or exploit consumers. Okay. Like I gave you an example of a particular kind of a fuel efficiency, okay, or a representation with respect to deployment of an airbag, which is an important safety mechanism in our vehicles. Now, many courts have held that the representations which are given in the warranty manual are not adequately communicated, and in many a times they are not adequately placed before the courts at the first instance, and therefore the issue of unfair trade practice arises. Okay, so we have had cases where even cases of underride accidents or accidents where vehicles have hit a particular pole, or during reverse of a vehicle there was an accident and the airbag did not deploy. We have had a case where a vehicle just moved out of the dealership, did not even complete 1 kilometer. The person driving the vehicle hits it in a divider and the airbag did not deploy. And such a consumer went to the consumer court, and the court has granted full refund to that consumer, despite the fact that an accident was totally the responsibility of the consumer and the airbags were not meant to deploy in such a scenario, because it was a minor accident. Somebody had just hit the divider of the road. Now, in this matter, when the matter comes to us at the National Commission level or at the level of Supreme Court, we always ask our friends that, did you make a request at the court of first instance, let's say at a district court in Amritsar, that let us get the vehicle tested or let us deploy somebody? Either you will make a request or an OEM. Ideally, an OEM must make a request. Whether the manufacturer made a request of this sort, we all see that there is no response. So therefore, in such a scenario, a person who out of his own fault has caused an accident, there was no scenario for an airbag deployment, ends up getting the full value of the vehicle, not just the full value, but also a 8% or a 10% interest or a compensation of 1 lakh rupees, which then goes on for us to think, and we think that this money could have been used in a lot of other meaningful and constructive things than what is called unscrupulous litigants, where we end up paying this money because people are trying to be very smart and we were very lazy in defending our matter at the right forum. Okay, so the practices such as false representation, misleading advertisement, fraudulent practices, and exploitative practices, they all come within the definition of unfair trade practice. Okay, Anshul, there are instances that we have listed. For example, advertisement exaggerating mileage figures, selling vehicles with undisclosed accidents or defects, or promoting a fake limited time discounts that are not genuinely there. These are all cases, these are all ongoing cases or cases that we have contested where these allegations were there for making out a case of unfair trade practice. we have handled matters where providing incomplete or false warranty coverage was considered to be an unfair trade practice, and also a case where adding hidden charges was without prior consent was considered to be an unfair trade practice. While it is important for us to communicate these charges well in advance, it is important that they do not give a ground for the consumers to raise an issue of unfair trade practice. The hierarchy of courts I've already explained to you. There's a district consumer commission, then there is a state consumer dispute redressal commission, and national commission. Okay. District forums are headed by people who are typically qualified or retired district judges. The state commissions are headed by people who are retired high court judges, and the national commission is headed by a person who is either the chief justice of a high court or a retired judge of the Supreme Court of India. And because all the matters from across the country end up before the National Commission, it is meant to be headed by a judge, a retired judge of the Supreme Court of India, typically. And this is the last body in the hierarchy. If somebody feels that I will be able to turn the tables at the level of Supreme Court, we are grossly mistaken. As I said, most of these things are decided at the level of district forum or state commission maximum. The kind of defenses that you develop, the kind of pleadings that you place, the kind of arguments that you place in writing before these courts pretty much foreclose the conclusion as to what will happen at a later level or at the level of an appeal. Okay. With this, let us go to the next slide, which is the process of complaint, appeal, and revision petition. See, I don't want to bore all of you with this process. It is more for lawyers that they follow these processes. What I really want to leave you with are some timelines, because timelines are in your hand. Okay. And breaching these timelines, you will do it at your own risk. So when a complaint is filed, you must first test that whether it is filed within the limitation period of 2 years. So ordinarily, the law says that a complaint, so one cannot say that I purchased a vehicle in year 2000. It had a problem in 2002, but I am filing a case in 2010. No. A complaint must ordinarily be filed within 2 years of the date of cause of action. Okay. So that is one. Number two, your reply from the date when you get the notice of a court must, and this is I'm saying with bold and underline for all of you to remember it must be filed within 30 days from the receipt of the notice. You may later on delay on a lot of other things, but this is something you don't want to delay, because that will come at a cost to your organization and it will forfeit your right for all the times to come. It must be filed within 30 days. And there is a very meager extension of 15 days which is granted. Meager extension of 15 days. And if your lawyer or your internal legal team is not able to file a reply within 45 days, we have had matters where for a dispute of 50,000 rupees, we have ended up spending 50 lakh rupees, and courts have not allowed you to file a response. Okay, so this timeline is quite sacrosanct. 30 plus 15, maximum extension by another 15 days. Secondly, for the purpose of filing an appeal has to be filed, as I said again, within 30 days. You are allowed some period of condonation of delay, but it is best filed as soon as you get an order. Okay, please don't create a scenario where you are challenging an order after 6 months or 8 months. You are taking decisions and files are moving from manager to general manager to head of departments and to various other people. Please, first file a composite response, file a composite appeal, and then everything else can happen later. If you have to withdraw the matter, you withdraw it later. But please follow the timelines. Next. National Commission. When you are coming in National Commission before under the revision provisions, you have a greater timeline of 90 days. The logic is that some of you might be based in Bhubaneswar, somebody might be based in, say, Bangalore. So for somebody to reach out to Delhi and then to file, so a slightly greater timeline is provided for 90 days. Many a times we also have to translate documents. a matter is filed in Oriya in Orissa or in Hindi in Madhya Pradesh, those documents have to be translated for the purpose of National Commission. So a slightly greater period is granted, but that is also no more than 90 days. So kindly try to follow this. And then apart from this judgment, there are some matters. So there are some matters in which appeals, not really appeals, a petition under Article 227, which is a power of superintendence of the High Court. Some of these petitions can also lie before the concerned jurisdictional High Court for correcting the errors which have happened in the process. And then, of course, anything and everything which is there is ultimately challengeable before the Supreme Court. But the ratio of admission in Supreme Court, as all of you must be aware or should be aware, is a meager 2% to 5%. So out of 100 cases which get filed, only 2% or 5% are actually admitted and heard and decided on the merits. Rest of the cases, because Supreme Court is only meant to look at the important legal questions or what is called the substantial question of laws, it really does not is expected to get into the nitty-gritties of facts of every matter. And it is assumed by them that the 3-tier of court which is available would have in its normal process come to the correct factual conclusion, and the Supreme Court is only supposed to look at the matter if it involves a substantial legal question. Okay. Now, with this, let us come to some of the heads of ways to reduce legal risk. Okay. See, I can make it into 50 different heads, but the bottom line is always going to be that a prudent businessman is the answer to all the vices. Okay. So whether it is proper documentation, prompt response, making full use of dispute resolution mechanism, clear written communication, written agreements, that helps the reduction of legal risk. It is very important that you keep this in mind. Communication, we have had matters last year, the vehicle deliveries were getting delayed. So many hundreds of consumers started issuing legal notices that I was promised a vehicle will be delivered within 3 months. It's been 7 months, and then they start writing to the OEMs and to the management, and everybody under the sun is on Twitter or X or this. Everybody is getting tagged and they are being informed, and a bad name is being created in the market. Okay. So while social media has given voice to a lot of those who would have otherwise found it difficult to ventilate their grievance, it has also caused a scenario where even when at the time of accepting booking, if we clearly communicate to them that this is the timeline within which we expect you to deliver the vehicle, or you have clearly admitted in writing that the booking is non-refundable, or if it will be refunded, it will be subject to this much of deduction. Such documented scenarios reduce the risk of a litigation later. And even if it does not, there may be matters where people will still land up in court and they will still fight those matters. It at least gives you enough grounds to raise a defense. Okay. All right. So compliance with laws, legal counsels have to be involved. People who are properly trained in this entire process. You see, it is important that you engage those who have some exposure of having dealt with such kind of disputes. It is also important that they understand the sanctity of the timelines. The attitude which we have seen in a lot of matters कि ये चल जाएगा कोई बात नहीं 2 महीना बाद भी फाइल कर देंगे चल जाएगा. All those scenarios ultimately lead to a problem. There's a very famous saying, a stitch in time can save you 9. So therefore, a proper response given in a timely fashion will definitely go a long way in protecting our interest. With this, let us come to one of the last and, according to me, a very important heading, which is product liability. Product liability, my dear friends, is important because it within its fold brings three very important ladders, or three very important players, which is, one is manufacturer, second is seller, and third is service provider. you as a dealer or a member of FADA, I presume that you will be wearing the hat of seller and you will also be wearing the hat of a service provider. So therefore, you are directly going to be impacted in case there is a product liability claim. Okay. However, not everything comes under your kitty. You should be able to adequately present that if there is a case of a manufacturing defect, then the fault in the manufacturing process or an car's engine or a braking system or an airbag or a design defect is something which has to be primarily attributable to the manufacturer. As I said, primarily attributable to the manufacturer. However, a dealer, because it's a dealer of a particular manufacturer, is expected to know that what are the potential hazards or defects in a vehicle and has a duty to point them out if they are in your knowledge. Okay. If they are in your knowledge is important, and has a duty to know diligently as to what is the defect, what is the possible defect, or what are the instructions that needs to be followed in order to ensure that all the warranty conditions are met. Okay. Similarly, what is the responsibility of our dealers? The car dealers are responsible for ensuring that the vehicles are sold in safe and free from defects conditions. There are matters of accidental vehicles, consumers raising a grievance after several months of purchase that I was sold an accidental vehicle. Then there are matters with respect to where the accurate information about a vehicle's condition, its service history, its warranties have not been provided. Now, those are the kind of product liability actions that you will come across in years to come. The area of product liability is now gaining traction. So far as you would have only heard of cases of simple deficiency in service. But product liability action will now increase, in my estimate, over the period of next few years. And the heads such as deviation from specifications, non-conformity of the warranty, and inadequate instructions given to the consumer can make us responsible. Okay. So, with this, it is important for you to look at the slide which deals with section 86. So Anshul, can you take us to the slide which deals with product seller liability? Product seller liability. This is product service provider liability. Go to the product seller liability. Yes. A product seller, which is not a manufacturer, is liable for a product liability action if he exercises substantial control over the designing, testing, manufacturing, packaging, or labeling of a product that has caused the harm. If the product seller has caused an alteration or a modification. So mind you friends, this is important. If you are in the process of selling, also carrying out an alteration or modification, which has led to the harm, then there can be a product liability action against you. There's an independent express warranty which is given. If the seller is liable, if the product manufacturer is unknown or cannot be served a notice, and the manufacturer is not subject to Indian laws, which is not really a condition because most of them have an incorporated entity in India. Failure to exercise reasonable care. So where we fail to exercise reasonable care in the process of assembling, inspecting, or maintaining the product before they are actually delivered to the end consumer. In such cases, a product seller liability may arise. And just a slide before this is the liability of product service provider. So as I said, you would also be holding the responsibility of a product service provider, and therefore our members are going to be possibly facing actions with respect to the faulty or deficiency in service, with respect to imperfect or deficient quality or the manner of performance. Negligence or withholding information. You see, withholding information is a head under which a lot of notices have now started to come in over a period of last 6 months, wherein in an airbag scenario, when a response is given by a manufacturer, it is told that we were never adequately informed. While as a dealer, you are not supposed to go out of your way and hold a special session for every consumer. Okay, it is considered important that you adequately inform them that the conditions of functioning of a vehicle or the warranty conditions are going to be strictly as per what is there in the warranty manual. Okay, inadequate instruction or warning to prevent a harm, non-conformance to the warranty or the contract. Okay, so these are the actions which can possibly lead into an action for product service provider liability. Okay. And then finally, there are various challenges that we face in managing consumer expectations, regulatory compliances, product defects. Uh, this brings me to the last portion, which is I just want to touch upon some 3 or 4 important judgments. Friends, the last year has not been really a very happy year insofar as the Supreme Court judgments are concerned. The courts, in their zealousness of trying to help the consumers, have in many matters held the manufacturers and in many matters the dealers responsible. It is important that I bring to you some important judgments which you may use in your ongoing cases. For example, this judgment came in the matter of Honda Cars versus Sudesh Berry. Okay. What is important is the findings portion, which is at the bottom of this. Facts are already mentioned here. So, the Supreme Court clarified that the manufacturers cannot be held responsible for deficiency provided by the dealers or service centers. This ruling limited the liability and distinguishing between manufacturer defects and the service related issues. This is an important judgment. I'm going to share this with my friends at FADA and they can circulate it amongst members, and members can use it because it's a Supreme Court judgment. It is going to embolden their defense in a lot of matters. Another judgment which came in year 2021 was in the matter of Tata Motors versus Antonio Paulo Vaz. Okay, this judgment was very important on the issue of principal to principal liability, and the Supreme Court held that the finally it was held that it is difficult to expect the manufacturer. So this is something which is going to help the OEM more than us. Manufacturer to be aware of the physical conditions of the car 2 years after its delivery to the dealer, unless the appellant's knowledge is proved. So therefore, in view of this judgment, my suggestion to all of you would be that whenever an issue comes which you think even is remotely touching into the manufacturer's liability, please involve them. Okay, they should not tomorrow be able to take a defense that we were not made aware of the situation of the vehicle or we were not made aware of the complaint which came. Okay, so it's very important that a proper written communication is open between us as dealership and the OEMs, wherein we inform them that this is the problem which is there. These problems are more in your domain. Please guide us in this process. And therefore, this judgment assumes some importance. The final judgment in the case of Daimler was on the issue of who is a consumer. Okay, so the vehicle was purchased by a company, and it was used for its employee, its managing director, I think, for his movement. Okay, and finally it was held that commercial purpose more depends on the intent and usage of ownership. Okay, so if there is no profit making activity involved, if it is used for the personal usage of one of the officers of the company, then also it will fall within the definition of consumer. Then another important judgment which I want to point out to all of you, and you will increasingly find a lot of actions coming from consumers. This judgment of Aisha Khan versus Mahindra and Mahindra. I had the privilege of representing the manufacturer in this matter. It was a long contested matter. We contested this for more than 10 years. There was a claim of about 10 crore, more than 10 crore rupees, which was there. And the case was of non-deployment of airbag in an underride scenario. A very long and a detailed judgment came in this matter. We also brought in the expert of airbags who was based in United States to explain the entire mechanism of airbag deployment and how does that entire thing functions for the court to understand that an airbag or any security system has its own inherent limitations. It is not meant to deploy at every road fall or a bumper or a small accident, and therefore the case of consumer is not really made out. Not a single rupee was granted, and the complaint was dismissed. And it is a long reported judgment which has come by the name of Aisha Khan versus Mahindra and Mahindra. The judgment is also important because despite the fact that some of the driver received some injuries, some serious injuries, the passengers also received some serious injuries. Court finally weighed in the fact that while on one hand, Mahindra took all the effort, or the manufacturer took all the effort to bring on record an expert evidence of somebody who is an expert in airbag mechanism, the consumer did not even ask for the vehicle to be tested. Okay. So the courts also realize that many a times people are only trying to file a speculative litigation, wherein let's just file a case of 10 crore rupees. Even if we get a 5 lakh or a 20 lakh rupees, it is bonus to us. Okay. So this practice was held to be a practice which needs to be discouraged, wherein matters of an automobile, which is a complex piece of machinery, one cannot allege that there's a problem in the vehicle, and for that reason there's a problem in the service, or there's a problem with the dealership having made certain assurances, unless they are properly tested. Okay. So having taken you through this detailed presentation, my request to all of you would be that kindly, it's a very simple piece of legislation called the Consumer Protection Act. It's available on the website of Ministry of Consumer Affairs. A simple glance through the provisions of this will help you in handling the notices better, will help you in handling the cases better, will make things much more smoother and easier for you. And I would finally leave all of you with a thought that 8 out of 10 matters where the responses are properly made at the district forum or a state commission level finally get decided in favor of either the manufacturer or the dealer. Okay. And most of the matters which do not get decided in our favor is happening because we are not able to present a composite defense, a complete defense at the stage of the lower court. Okay. So thank you very much for very patiently hearing me. I see some 83 people are logged in. So if you have any questions, if you want to know more about any particular thing, please do ask.
Thank you, Anandji, for making such a comprehensive presentation and refreshing all our old memories. We have few questions which I'm reading from the Q&A box.
Yeah.
And in the meantime, I'll request members, if they have any doubts, they can mention it in the Q&A box and not in the chat room. First question is from Mr. Ehsan Khan. Will there be any infringement of consumer right if an OEM enforces or implements territory or of sale by dealer?
Sale by dealer. So there was a matter which was going on, but this is not a violation of consumer rights. This is a issue which squarely comes under the domain of Competition Act 2002. Okay. So if a particular territory is enforced, it is possibly an action which can be taken before the Competition Commission of India. But see, Competition Commission of India has a different threshold or a test, which is appreciable adverse impact test. So whether by demarcation of a territory, whether number one, the benefits which are flowing to the consumers are stopping, and whether it is creating an imbalance in the competition in the market. If that holistically leads to an adverse appreciable impact on the market, now these are very vague terms, so to say, meaning thereby अगर market पे बहुत ज़्यादा असर पड़ रहा है, then you will have an action. Then one dealer can possibly take an action against that manufacturer before the Competition Commission of India. You can lodge a complaint before the Director General, Competition Commission of India may investigate into the matter and finally hold this to be in violation of either Section 4, which is called the abuse of dominant position, or this also may fall foul of Section 3 of the Competition Act.
Okay, so next question is coming from Jodhpur, Rajasthan. Mr. Jayesh Dhoot is asking, like one case is done by consumer in a city. Can we ask for video conference hearing?
Yes, you can. So you see, that's a very good, very interesting question. Supreme Court, in fact, under the leadership of Justice Chandrachud, made very serious progress in the area of video conferencing hearings. And now, while you see, unfortunately, most of our courts are still ill-equipped. Even at Delhi level, we find that maybe out of the 10 districts, only 5 are functional on VC. You have a right under the new law to make a specific written request that I want the benefit of a VC, and the court is obliged to grant you. And I would want to see a scenario where they refuse, because if they refuse, that itself becomes a ground to raise a challenge later. Okay. So when you are filing a response or you are giving a representation, please write to the court that for by matter, I want a VC hearing. So please take advantage of that. There's a specific provision for it.
Okay. Mr. Siddharth is asking, can a customer challenge mobile OTP consent taken during sales or service of a vehicle?
See, mobile OTP is basically a method of authentication. Okay. Now, it will completely depend on the scenario. You can't, if the consent is taken for so many things by way of a single OTP, yes, it can be challenged. Can I service your vehicle, put a engine oil of a particular model and do ABCD things? No. If you give complex instructions and seek an acceptance by way of a single OTP, maybe it is open for challenge. Okay. So it is better that you have other modes of documentation. Like you have developed OTP, maybe you can have push buttons by which they will put a yes or no on a small responsive chat and they will respond to it. While these are things which can be proven as an electronic evidence, if your instructions or the consent is sought for very many questions at one place and answered by a single OTP, then maybe some problem may arise.
Okay. If documents are not clearly submitted by claimant, can the time limit of 45 days be waived off or not?
By the claimant or by us? We are going to be respondent usually.
Yeah, so I'll assume that it is for us.
So if it is for us, see, we are going to be respondent, the claimant will be the consumer. Time limit is of 30 days. Let me remind you once again. It is extendable up to 45 days if you have some difficulty, some demise in the family, so something like this. But it should be filed within that period. If you are not able to file, you will have to demonstrate. The simple test is to explain as to why you were not able to get those documents within that time frame. If you have a valid reason, my things were stolen or office was shifting, then maybe you can introduce, but do file a response within 30 days.
Okay. Similarly, can a National Commission take a case after 90 days or can we challenge the timeline?
See, they do accept cases after 90 days. The bottom line of the test is that whether you have a valid cause. We have had matters during COVID, cases have been filed even after 200 days. We have had cases where due to bereavement or some other scenario, cases are accepted after 6 months also. But the cause which you are giving must be valid, genuine, and if possible, as much as possible, backed up by documents.
Okay. Since dealers use the dealer management system, the DMS, and which is owned by the principal OEM, and every complaint of customer is therefore registered on the same. Still, do we need to send email letter to the company for manufacturing complaints?
Basic idea is that there should be clear communication. Okay, this latest judgment of Tata basically shows us that in that matter the liability finally rested with the dealer friend. Okay, so unless you are able to show that they were adequately communicated, and an adequate communication may be email, it may be under the DMS intimation, then you must be able to give a screenshot of that or a printout of that to show that when it came within 3 days or within 7 days, I informed it further. Okay, if you can show it on that portal, that is also good enough.
Okay. Suppose I am, this is asked by Ankur Gupta. Suppose I am running a consumer lucky draw scheme on purchasing of each vehicle, giving free goods like bikes, TV, etc. under lucky draw scheme. So is there any government body to whom I should provide the TNC of the consumer lucky draw scheme?
No, there is no such body. You must have it vetted by a lawyer if possible.
In case Mr. Pratik Jain, our state chairperson of Uttar Pradesh, is asking, in case of rejection of insurance claim, can dealer be held liable?
The plain answer is no, but there is a small nuance. Many a times in such cases of rejection, dealers are also made parties and they end up fighting the matter. But for an insurance repudiation, never. It's a contract between insurer and the insured.
Mr. Indrajit Das is asking, how can we reply para-wise against one notice? I didn't understand. Maybe you will be able to.
Can. I mean, you can.
Okay. So Deepak is asking, is dealer allowed to scrap the vehicle which are dumped by customers after accident and they don't turn back?
Well, there has to be scrapping the vehicle must be under a express policy. It depends on how under what condition the vehicle has come. Okay, it cannot be done without the consent of the vehicle, and if it is happening that the consent is absolutely impossible to get, you should be able to demonstrate that I have adequately tried to approach the consumer multiple times by multiple modes and only then. But it's not a good idea to really scrap the vehicle.
So Mansingh Pawar from Maharashtra is asking, at the time of delivery of vehicle, there is some minor irritants due to which the vehicle did not start. The consumer is asking replacement of the vehicle as the vehicle is registered. A lot of cost is involved. Please advise, how do we handle this?
We have had such scenarios with a lot of dealer friends and OEMs where small issue, something very minor comes and then the consumer says, no, I want a new vehicle. See, you are not obliged to do that. And we have had matters where we have successfully contested and the courts have said that you are not obliged unless and until the functionality of the vehicle is hampered. Okay, if there's something superficial while getting it from the yard to the main place, if it gets a scratch or two, that's not good enough a ground for replacement of vehicle. It's already registered in someone's name, so you are not obliged to really register it or give him a new vehicle.
If Mr. Sambhaiya God is asking, if consumer is not submitting his evidence for 60 days, also then how many days it can be kept on hold for judgment?
Okay, so I will give you a response from the book and response in reality. The answer is, by the book is, of course, their right can be closed. But in reality, consumers are treated with kid gloves like small children. And we are treated like, they are dealing with some monster. So all timelines, all restrictions will be tested against you. Okay, consumer will be given 60 more days, 50 more days. So you should try to keep your compliances within time.
Okay, Mr. GVS Kiran has a long question. He has wrote the entire scenario. A customer recently made prepayment for a bike and later requested a cancellation. Regrettably, a delayed response from our representative prompted the customer to file a complaint with cybercrime authorities regarding a potentially fraudulent transaction. As a result, our business account has been temporarily frozen by the bank, hindering our ability to process transaction. The bank and cybercrime authorities have advised us that the account will be unfrozen only after the customer withdraws their complaint. We find the situation to be unfair. How do we go ahead with this? Or how do we
Very unfair. It is quite unfair. And so point is, if your bank account is with a private bank or a public sector bank, one of the quickest remedy, if you are having a substantial amount of money in that account and there's an FIR, then you go to the High Court and seek a direction by way of the criminal writ. The courts are usually very reasonable in unblocking such accounts. If a small amount is sitting in that, then I would request you to go and make a representation to the concerned SP or the commissioner for deblocking. What you can tell the commissioner, and which we advise, is, let's say my account has 100 rupees, the dispute is of 5 rupees, I'll secure that 5 rupees, let my main transaction go on.
Arjun is asking, dealership company and dealer principal are two different entities. How can dealer principal be protected from any such case being filed?
Well, if protection is absolutely no filing of case, that's not going to happen. The protection is in the process. You follow the process, put all your defenses in the right fashion, and then you will remain protected.
Our member Dada Motors from Punjab, they're asking, what is the status of consumer law in the sale of commercial vehicle if a fleet owner purchases from us for commercial use? I think you've already answered. Can they file
Yes,
a complaint against us in
this
such?
particular law is not for commercial fleets. For that, they can certainly file a civil action or a civil suit they can file. That is different.
Okay, if the EV vehicle is there's a
Accident.
mishap in the EV vehicle, what is dealer and OEM liability in that?
Completely depends on the terms and condition, the nature of mishap. I presume that the mishap is primarily attributable to the OEM, so it's OEM's responsibility.
So Sandeep is asking, we have received a vehicle in accidental repair 1 year back. It is a major accident vehicle, but customer is not responding to our call letters. Okay, can we scrap the vehicle? I think you already answered it.
If there is a pending FIR in the matter, then seek consent from the concerned SHO and then scrap the vehicle. If there is a case going on, then move an application to the concerned court and seek a permission for scrapping the vehicle. They permit you to scrap the vehicle, and they ask you to keep the money of that scrapping in a particular account. You keep it in a particular account.
So Anil Sharma has asked, can a consumer demand a new vehicle after registration and insurance after a period of sale of 1 month or more?
He cannot, but on what ground?
Yeah, that ground is missing here. So
Yeah.
Mrs. Surekha Pant is asking, customer is asking cancellation of vehicle and refund of money paid 100% at the time of delivery. Can he go to consumer court and what remedy can he get?
See, Mr. Pant, we are in a democracy, so anyone can go anywhere, but he's not going to end up getting anything.
Okay, so last question is from Mr. Vaibhav. Sir, how can we recoup our money in cases where customers have not taken vehicle given for accidental service vehicles which they have not taken for years? Vehicle has been stacking up. So this is similar to question what we two questions earlier.
Take permission from court, sell the vehicle, keep the money, keep it in a particular account so that tomorrow, if there's a liability, you at least won't have to handle the hassle of handling the vehicles as such.
Okay, I'll just take last one more question. After running 2 years and more, then that can customer can go to consumer forum for changing the vehicle after 2 years of running of the vehicle.
See, he can. Usually, they don't. They try to make out a case saying that I've suffered a problem throughout. So it is very important that the entries made in job card are kept in that fashion. Satisfaction notes are taken at all the times of exit. Okay, and if he still has a problem, see, you can always foresee who's going to turn out into be a litigious customer over a period of time. Try to take satisfaction note, document all his concerns over email. If he has to go to court, let him go.
Just the final one I'll take this because it's a new question. Can customer get external PDI team do the inspection of the vehicle?
Typically, no. The warranty is issued by the OEM, so an external entity cannot get engaged in that process. For his satisfaction, if he wants to do it, he may very well do it after the vehicle leaves our sales station. And but then the findings of that body is not binding on me. The warranty is issued by the manufacturer. It has to conform to the standards of the manufacturer. Full stop.
Great. So I think Anandji, we have overshooted our time limit of 9 minutes.
Sorry for that. 7 minutes is a very long time.
No, but it shows that how engaging our members have been with this webinar and how interesting this topic is for them, and it's of a lot of concern for all of us also.
Yes.
Amar bhai, are you there on the call? Okay. So So Amar bhai, I think we are through with the webinar.
I think it was really spellbinding and a lot of complexities resolved, but certainly the law is dynamic, it keeps changing, but we need, as auto dealers, need to be on top of the subject and aware of what we need to do. So thank you, Anandji, for giving us all these
Thank you very much. Thank you.
Direction forward.
Thank you. Thank you. I will be sharing some of these judgments which you can circulate amongst the members, and they can use it in either ongoing matters or future matters. And it's an ongoing process. If you have any further queries coming in, please share it with us. Thank you, Anshul, for coordinating this entire session.
Thank you so much, sir. Well.
Thanks a lot, Anandji, for this enriching and enlightenment session, and to all the members. stay tuned, because in days to come or in months to come, we'll also do a Personal Data Protection Act webinar, which is of utmost importance in times to come. So we'll keep you posted, and thank you for attending today's session. Have a great weekend ahead. Thanks a lot, Anandji, for all the time which you're given to us.
Bye.
Thank you. Goodbye.